you from a little town called Highland, which is midway between Baltimore and Washington, D.C.
I'm Chuck Dunlap. I'm Executive Director of the Indiana Bar Foundation in Indianapolis, which is where I'm joining you from right now. And I'm also an adjunct professor at Indiana University. Good to see you all and look forward to hearing more from you soon.
Would you please introduce yourselves and your teacher?
I'm Anna Adams.
I'm Duncan McSorley.
I'm Emma Lettie.
I'm Will Casey, and we're all seniors at Raleigh Charter High School in Ms. Klein's class.
Very good. All right. Okay, so you know the drill. I'm going to read the question all the way through, and then when I stop talking, that's your cue. When you guys start, Ellen will start your time, okay? Richard Posner wrote that the American public worries more about invasions of privacy than about summary proceedings against suspected terrorists, curtailments of the freedom of speech of the law-abiding, or the right of the media to publish government secrets. Do you agree or disagree with this statement? Why or why not? To what extent, if any, is privacy in jeopardy today? And what protection, if any, do people have from privacy violations by governments or businesses?
While we agree with Richard Posner's assessment of the values of the American public today, we disagree as a group on whether or not this is a problem. We asked ourselves if we felt comfortable sacrificing our privacy for national security. I feel safer knowing that the small sacrifice I make by giving up some of my privacy will ensure that technology does not become an open area in which criminal activity and terrorism can occur. Other members of my group, however, value privacy to a much higher extent. They do not feel comfortable making such a sacrifice.
Many indirect protections of privacy are found in the Constitution that protect citizens from violations of privacy from government or businesses. For example, the Third Amendment prohibits quartering troops in private homes, the Fourth Amendment protects citizens from unreasonable searches and seizures, and the Fifth Amendment protects citizens from compelled self-incrimination. Supreme Court cases and legislation have also been used to further establish our privacy protections, especially as technology advances.
Legislation to protect citizens' privacy has also been established, such as the Health Insurance Portability and Accountability Act of 1996, or HIPAA, which works to protect private information carried by health insurance industries. Privacy protections from businesses are limited, as we sacrifice our data protection through privacy policies, such as terms of service agreements. However, one example of a current protection from privacy violations of businesses is the Children's Online Privacy Protection Act of 1998, which restricts what data companies can collect, share, or sell about children under the age of 13.
In Katz v. U.S., a recording device was deemed an example of a search and seizure and therefore required a warrant under the Fourth Amendment. This not only expanded the definition of what constitutes search and seizure, but also established the Katz test to determine whether one's Fourth Amendment protection against unreasonable searches and seizures has been violated. This test asks whether the person exhibited and understood the expectation of privacy, and if this expectation can be considered reasonable and commonly held by the remainder of society. Though this test is a step in the right direction towards further privacy protections, our right to privacy is still not sufficiently protected.
Technology has drastically changed the way we view privacy and what constitutes an intrusion or violation of that privacy. On one hand, technological advancements and surveillance have furthered the ability for law enforcement and intelligence agencies to gather information. Numerous government agencies, such as the National Security Agency, the Department of Homeland Security, and the Federal Bureau of Investigation, intrude upon the communications of citizens by using extensive databases to store suspicious activity, which is yet to be defined.
This enhanced technology has the potential to intrude on people where they may have reasonable expectation of privacy. Facial recognition technology used by the government and businesses has the potential to pose a huge threat to individual privacy rights. Protections of privacy violations from the government and individual liberty must keep up with changes in technological advancements in surveillance.
Threats to privacy exist from businesses as well. Social media platforms and network providers have created a sphere where many people store and share their personal information and much of their lives. People instill a great deal of trust in these corporations to keep their information private, but there are examples of where this trust has been breached.
According to the New York Times, the National Security Agency's ability to spy on and monitor masses of internet traffic through the U.S. has relied on its long-lasting relationship with AT&T. One document that was discovered even described the relationship as highly collaborative. This is a clear threat to privacy because we cannot even trust network providers to keep our information private. The threat to privacy through the internet spawns from both the people and the US government to obtain our personal information. Thank you.
All right, great. Thank you so much. So picking up right where you left off in that discussion about the NSA collaborating with AT&T, is that legal, and should it be?
We see that, throughout periods of history, we've, loosened our liberties in order to protect national security. So, it depends on who you're asking, because whether or not they're doing this to protect national security, it defines whether or not that's legal. So, one might consider that their collaborations are not necessary and that we don't need them, while another might consider that it's extremely necessary to prevent, terrorism and other criminal activities.
Echoing off of that, our civil liberties are always in flux when it comes to issues of national security, and there's a balance of freedom and security that has to be maintained based on the situation. And so I would agree with Anna in that it really depends on what the situation is and whether there's a clear threat to national security, whether the NSA can step in and make those types of violations. Which
But
I think,
is there a question that we need to answer first? Does AT&T have the right to that data? Or let's talk about Apple. Where does Apple get the right to use your personal data?
So I think a lot of times people sign into contracts that give up their personal information when they use network providers like AT&T when they buy an Apple iPhone. And so I think the difference is that the situation is that people are signing contracts that they might not necessarily be understanding or reading fully, and they often are disguised or seen as terms of service agreements that are long and complicated and not fully understood by the consumer. So that's where people, I think, are giving up their privacy rights, even if they might not want to. So is the greater threat then from the government or from private entities? I mean, their Constitution doesn't limit the power of private entities. Is that where the greater threat is coming from now?
I definitely think that we can see that the greater threat of privacy violations is coming from, businesses and companies, because with the government, we have Supreme Court cases and legislation and the Constitution to look for where our rights are violated and what rights exactly we have. But with businesses and our data, there's not much that we do know that's going on. So for example, in the European Union, they have the General Data Protection Regulations, which establish a ton of, data restrictions on what businesses and companies can do with their data, but it also gives a lot of power to the people whose data they're collecting, and that they can see what data is about them and even in certain circumstances erase that data. I just don't think we have that power here in America.
Why not?
I mean, I think we don't have that power just because in America we value businesses to a higher extent than the people. And I mean, even we see the NSA is working with AT&T, so it wouldn't benefit the government if we did establish those protections for the people.
I will say there are some examples of where business has protected our privacy above the government. In the case of the San Bernardino shooter, Apple actually worked against the FBI, who were trying to get Apple to create software that would allow the FBI to decrypt Apple iPhones. And so in that case, business actually protected our privacy above the government, or more than the government was trying to.
Also, going off Supreme Court case protections, in the case Carpenter v. US, the cell site information gathered by police for investigation went against Carpenter's Fourth Amendment right to no unreasonable searches and seizures. So I think it's important to note that just because people may store information on online businesses or on social media or on third-party servers, that information should not lose its Fourth Amendment protections or any protections for that matter. So I think if people are willing to trust, let's say, government or businesses with that information, they shouldn't abuse their power to exploit that information.
Back in the current, sorry.
Go ahead, Will.
I was going to say really quickly, back to the original question. I would actually I would say that the government is actually a greater threat mainly through the effect of right now using tracking apps, or the idea of using tracking apps in the future is a greater threat than what the businesses are doing now.
Well, that actually goes into my next question, which is, in the current crisis, when you're looking for contact tracing and tracking of movements by the government in the name of public safety, how should the courts analyze that and balance that versus public individual privacy? And once it's gone, can you ever get it back as far as the privacy that you've given to the government with technology?
Yeah, I definitely think that would be a huge concern among Americans, because we value our privacy to a high extent. But we have seen that in other countries such as China, where they use tracking apps, to get into public places, and its precision is down to like what train car you're in. They have been able to open up more public places and restaurants and schools. However, like compared to other countries, it could be said that America is not doing enough to protect the spread of this pandemic. But even then, we've seen protests all around the country of the limitations that we have put in already. So I just don't think that we could ever establish something like that based on the fear of Americans of protecting their liberties.
An interesting example of this also, in Russia, they've already implemented a tracking app that also gathers data information through their camera and through their internet usage. And there's already a lot of opposition groups protesting this, that maybe it will stay in place after the pandemic.
Great, thank you very much. Nice job, everybody.
Absolutely.
Virtual clapping. So we'll do a bit of feedback. I'll start. I thought you all did a great job, very, very meticulous kind of opening, starting from, where in the Constitution we can find references to privacy, and then bringing us to kind of through all the legislation, and then into kind of the business arena. I would have loved to tease out a little bit more where we just ended, which is like, what if Apple or Facebook decides to use all the data that they have, and we put the government aside, and they're the ones that are, trying to identify, who has COVID-19, and you can just tell on Facebook if the person across the street from you has it. What does that look like? Can law enforcement use that to ticket people who aren't social distancing? There are like a ton of different ways we could maybe get at this without going into kind of where China is at, which I think to your point, Anna, everyone's a little bit, we would draw the line, I think, before we got to what China is doing. But great discussion. I would have loved to stayed and talked more. So good job.
Yeah, no, this is great. I wish we'd had more time. If this had been like a Monday, I think from what I've seen, you guys would have had a very good chance of being one of the top 10 teams. And so we would have had more time to develop some of these things. But I just want to give you a shout out. The reference to the European Union and to Carpenter v. US. I don't think we've yet heard references to either of those this morning, and they are like totally on point to this. And I was actually surprised that we had, we've heard references to third-party doctrine, but no one that I recall sort of noted that the third-party doctrine is maybe on life support now in light of the Carpenter decision. So I was very impressed by that. The reference to Apple and San Bernardino, if we had more time, I would have asked, well, should it be optional with the individual companies whether to sort of take the position that Apple took or not? And is it even a good idea? Doesn't allowing Apple to do that, doesn't that implicate the Posner's not a suicide pact? I mean, so isn't that suspect in a time of national emergency? So I don't doubt you guys would have great answers, if we'd had time to ask those questions. So congratulations, Ms. Klein. Thank you. What a great team.
Yeah, I agree. This was a lot of fun, and it was obvious that you have a really strong depth of knowledge in this area. And to me, it's interesting, the intersection between, and we talked a lot about it, and we could talk more, public versus private interactions, and how much does the government rely on private industry, and what role do they have? And then when you get out of the idea that the Constitution is protecting us against government action, then you get into the legislative, arena. And you talked about the European Union and where we stand maybe as it relates to them. And, maybe we're not as progressive on our privacy protections legislatively as the European Union and others have been. But it's such an evolving field. And, every day, and the current situation is going to set precedent for how we handle these things. And you guys will probably be around a lot longer than we are to see even more technology increasing in the future, and how it impacts the Constitution and public policy within our country. So it's great. Great job. Thank you again to your teacher. It's clear that they had a busy semester despite the current situation. So thank you all.